Morning, everyone. We're going to make a start. People are still joining, but hopefully they can catch up. Morning. My name's Rob. I'm a partner here at Fenchurch Law. I'm joined today by Jess. She's a senior associate here at Fenchurch, and we're going to be talking to you about building liability orders and asking whether they are the next wave of coverage disputes. So a bit of housekeeping to begin with. We think the session will probably last around 35 to 40 minutes, so we should have some time for questions at the end. I understand that on your screen you should be able to quite easily see the Q&A box. So if there are questions, but only easy ones, please pop them in there and we will try and deal with them at the end. A recording and a copy of the slides will be sent around tomorrow afternoon. So here is what we're going to cover this morning. If you click it for me. Thank you. So here's the agenda. So we're going to start off with talking about what building liability orders are and how they're intended to operate. Jess is then going to go on to talk about building information orders. I will then be running through where we are at present, the current landscape, and how the courts are grappling with BIOs and BLOs. We're then going to talk about some of the potential challenges to insurance cover, and hopefully some potential routes to that insurance cover. So I'm going to hand over to Jess.
So firstly, what are BLOs? So BLOs were introduced under Section 130 of the Building Safety Act in 2022. Their purpose was to address the possibility that developers may escape civil liability for safety defects by virtue of having carried out the work through subsidiaries, shell companies, or SPVs. Previously, it hadn't been possible to pierce the corporate veil, but now such an order allows the court to extend liability to associated companies. So let's consider what is required under the Act for the court to award a BLO. So essentially, there's three elements. Firstly, there has to be a relevant liability, and that's defined in the Act as being a liability of the original company incurred under the Defective Premises Act, the Building Act, or as a result of a building safety risk. Then secondly, the companies have to be associated. And under the Act, being associated means if one of the companies controls the other or a third company controls both of them. And controls is also defined in the Act, but it includes things like one of the companies owning at least half of the other's share capital. There isn't yet so there must be then also an associate. There must be associated during the relevant period, which is defined as being from the commencement of the works to the making of the BLO. And then thirdly, the court must consider it just and equitable to make such an order. Now, whether it's just and equitable will depend on the case and will be fact specific. And there hasn't yet been any case law on that, which indicates the exact approach the court will take in determining what just and equitable is. But Rob will come on to discuss the direction of travel from recent cases shortly. It is also worth noting that during debates in the House of Lords, it was suggested that factors which may be taken into account include things such as the nature of the defects, the extent of the damages sought, and whether a fair trial can take place. Let's now have a look at an example of how a BLO may work in practice. So a 14-storey residential building is developed by Company A. A few years after it's completed, serious fire compartmentation issues are discovered. The freeholder then investigates a possible claim against Company A under the DPA on the basis that the building was unfit for habitation. The freeholder discovers that Company A was dissolved once the building was completed and the freehold sold off. So the freeholder's lawyers advise that they can establish that Company A's parent company, Company B, is associated, as Company B directly controlled the actions of Company A. So the freeholder applies to the High Court for a building liability order against Company B, and the order is granted. The freeholder can now use the BLO to attribute liability for the DPA claim against Company B in place of Company A, the original developer. So before Rob updates us on the recent authorities, let's briefly consider what building information orders are, because these were also introduced under the Act. So the Act allows a party making or considering making an application for a BLO to apply to court for a building information order. If awarded, a building information order requires a company to give within a certain time frame specified information or documents relating to persons who are or have been within a specified period associated with that company. And under the Act, building information orders will only be made if a court considers that the company is subject to a relevant liability and it's appropriate to require information or documents to be provided. Rob will talk a bit more about the guidance that came out of the Ardmore building information order case in a moment. But taking our previous example, if the freeholder had been unsure whether Company B was in fact associated with Company A, it could consider applying to court for a building information order, and that would then allow it to make a decision as to whether it should apply for a building liability order. And if a building information order was awarded, it would say something along the lines of Company A within 14 days is to provide XYZ, specifying whether Company B is associated with it. So Rob's now going to take you through the recent authorities concerning BLOs and BIOs.
Thank you, Jess. So it's worth noting at the head that there's actually only one decision where the court has made a BLO. That's in the decision of Click. I'm not going to cover it in great detail here because it was subject to a webinar that my colleagues Joe and Alex gave earlier in the year. But I think the point to note here that the example in the scenario in Click was that archetype example that Jess was running through from the explanatory notes. So we had a thinly capitalized special purpose vehicle. It was part of a wider group, albeit not a big group. The court was asked to make a BLO. My understanding is that for the most part, the BLO defendants left the claim undefended, essentially, so they weren't even legally represented at the hearing. The judge found that the companies were associated with each other. There was all one controlling mind. And she didn't go too much further when considering whether or not it was just and equitable to make the BLO, other than the finding that the companies were associated. But what are we seeing in practice? Well, certainly in our experience, what we are seeing is that these BLOs aren't being used against developers. What they tend to be used as is against the project teams themselves. So either developers against main contractors or main contractors downstream. And why that might be, I think the answer, or at least one of the answers, comes from the other ways in which claims are being made against developers. So first up, we have the developer remediation contract. As at May 23, so we have here on the slide, as of May 25, 53 developers have now signed that contract. Now that gives them a primary responsibility to make good these defects and to make sure that leaseholders aren't having to pay for the cost of remediating their buildings. I mean, that's a huge burden on developers, and understandably, they are now looking at other ways, including BLOs, to recover some of their losses downstream. The other thing to note, and I'm going to come on to it in a bit more detail, is remediation contribution orders. Now, these were also introduced by the Building Safety Act, and they operate similarly to BLOs in that the court can order developers, landlords, or their associated entities to contribute to the cost of making good. So, although our view is that the BLOs seem to have been introduced as a mechanism to recover funds from developers, that isn't how they're being used, as the cases, as the recent cases so demonstrate. So first up, this decision from about 18 months ago, Winwood Dixon versus Prater. Now, this concerned a fire safety claim. Winwood Dixon was looking to recover from its supply chain. And this particular judgment concerned an application for a BLO that was actually bought by one of the AECOM companies against Prater, who were the facade contractor, against their parent companies. And actually, at the time, this judgment received a lot of interest. It was described by some as being groundbreaking, that you would have BLOs being used in this possibly previously unthought way. As I said, it's very different to how the explanatory notes were describing these BLOs. So AECOM made an application for a BLO against Prater, and this judgment concerned whether or not the BLO application should be stayed, or whether it should run alongside, the BLO claim should run alongside the main action. What inevitably happened is that the companies all then brought BLO claims against all the other companies and their parent companies, etc., etc. So there was a cascade of BLO claims flying around. I think the interesting point from this case is what it actually didn't say. I mean, the judge didn't say that the way that these BLOs were being used or being sought to be used was somehow inappropriate or outside of the scope of the statute. So, this is the only other case where BLOs have been discussed alongside CLIC, and the fact that we don't have the court saying, hold on a second, what are you doing, ACOM going against Prater's parent companies, is of itself super important. In terms of procedural aspects, and it's here on the slide, but the court said essentially that if there were going to be these ancillary claims for BLOs, that it was generally be sensible and efficient for the company against whom that order is going to be sought to be made a party to the litigation, and for that application to be heard together with the main claim. The court took a slightly different approach, or suggested approach, in the Ardmore case that I'll come on to, but to me this seems probably the most sensible way to do it, because there will inevitably be arguments raised in the main claim which will factor into the just and equitable assessment. So, for example, if ultimately one of the supply chain is predominantly liable for what went wrong, I would have thought that parent companies of those higher up the chain will want to rely on those arguments to say, well, hold on a second, it's not just and equitable for a BLO to be made against me, because it's the architect, it's the fire engineer, it's someone else. So the approach suggested here seems to make the most sense, but obviously the facts will dictate on a case-by-case basis. So moving on to Ardmore, BDW and Ardmore, as Jess said, this case concerned a BIO. It was part of a action enforcement decision. So BDW actually adjudicated against Ardmore Construction in relation to a development called Crown Heights, a very old development, which I think achieved PC in 2003 or 2004. So the actual underlying claim of itself is very interesting. I think it was actually the first case of that type to be referred to adjudication. So essentially the adjudicator was determining a DPA claim. Ardmore resisted the enforcement of that decision on that basis. Essentially that the court or the adjudicator didn't have jurisdiction to determine a DPA claim. Unfortunately, they were unsuccessful in that. BDW then used those proceedings to apply for a BIO. Essentially, BDW was saying this is one of many claims that we have against Ardmore Construction Limited, and we want information from it about its associated entities to allow us to decide whether or not to bring a building liability order. BDW's application actually failed for a number of reasons. The first one is that the information that BDW wanted was actually information that was held by Ardmore Construction Limited's associated entities. It wasn't held by Ardmore Construction Limited itself. BDW couldn't get a BIO against associated entities. It could only get a BIO against the main entity, so here Ardmore Construction Limited. The court didn't have to go on to make any other findings, but it said obiter that a large number of the documents that BDW was looking for, it wasn't entitled to, so it didn't need kind of granular financial details in order to decide whether or not to bring a BLO. And it also said that some of the documents, as I said, weren't actually in ACL's control. I think this point here is quite important, because although I think the outcome of this decision is that BIOs aren't going to be used all too often, there's quite a lot of hoops for people to jump through. The court did say that in order to make a BIO, it would have to make some kind of finding in relation to relevant liability, but it said that applications under this section should be short and uncomplicated. And he said that it did not impose an obligation on the court to become embroiled in assessments of the merits of disputed matters. So essentially BDW could have found some way in their application to say, yes, there is a relevant liability, and this is how we get there. But unfortunately, in this particular instance, it didn't do enough. The other interesting point about this decision is the one that links to Wilmot Dixon. So essentially, the judge said here that BLOs could be made preemptively. So you actually don't have to establish that relevant liability of the underlying defendant in order to bring your BLO. I think the current thinking is that you need to have either they need to be added to the main proceeding, or you have some other kind of dispute resolution mechanism. But the judge here took a contrary view. He said to him it made perfect sense to allow a building liability order to function as what might be termed an indemnity. So effectively, to make the BLO preemptively. I suppose I can see the logic in that. There will certainly be cases where a BLO application of itself will be very complicated. It might go to, the financial benefit received by parent companies. It might go to kind of less tangible benefits received, all those kind of things. So they could be very expensive proceedings to defend. So I can see the sense that knowing at the outset whether or not the BLO is any good might lead to a cost saving in due course. But equally, I can see that if you were looking at just and equitable, and those same arguments are going to be raised in the main claim, that it might be more cost effective to hear the two together. It probably depends on the facts. The next case is Trifon Homes. This concerned a remediation contribution order. Interestingly, it was actually a leapfrogged appeal from the first tier tribunal straight to the Court of Appeal, given the importance of the decision. RCOs generally considered to be analogous with BLOs. I think that's clear from the judgment, and importantly, they also contain that just and equitable requirement. So here, Triathlon Homes pursued the companies of the original developer, including Get Living, and they also had building safety funding at the time of the decision. The Court of Appeal rejected the appeal and upheld the remediation contribution order, compelling the associated entities to pay in the region of £17 million in respect of remedial works. Get Living and the other applicants made a number of arguments as to why it wasn't just and equitable for these remediation contribution orders to be made. In response to that, the Court of Appeal said that essentially the Building Safety Act places primary responsibility on developers. I think here the court was really at pains to say, yes, there is that primary responsibility, but it's not necessarily the end of the story. And that comes from, again, the first tier tribunal, where there's this debate about whether there is a presumption that just because there is a developer, they might have the means to pay the BLO or the RCO. Therefore, it's just and equitable for them to do so. I think the court were clear here that although there is that primary responsibility, they didn't want to go as far as, and there's a kind of automatic presumption. The court said it was not unfair for the RCO to be pursued in place of the other claims. So this is really about that kind of supply chain claim. Get Living was saying that an RCO shouldn't be made because there are other claims that Triathlon Homes could be bringing, most notably against its supply chain. So it should essentially exhaust those other claims and remedies before it brought an RCO. And the Court of Appeal wasn't persuaded by that. The other takeaway here is that Get Living was arguing that it didn't own the relevant entity at the time that the works took place. It didn't receive any kind of financial or tangible benefit from the development. And when it acquired the company, it can't or couldn't have known about this potential liability some kind of 10 years later coming down the chain. Unfortunately, the Court of Appeal also wasn't persuaded by this. They said that investors will be taken to have assumed the liability risks of kind of historic acquisitions. More helpfully, the court did give some guidance on when it might not be just and equitable for an RCO to be made, and as I say, probably analogous to a BLO. So the first example they gave was if the associated entity was engaged in an entirely different business to that of the kind of underlying entity. And the other example was of a charitable company. So where, there's shared directors and one director just happened to be director of a charitable company. It might not be just and equitable for an RCO or a BLO to be made in those circumstances. Thank you. I thought it'd be interesting to look at some cases that are in the pipeline. So as we've seen, we've got a bit of a mix of where we are at present, but we only have 2 cases on BLOs and only one case on RCOs. But there are certainly some coming down the pipeline. So we have 2 here, both of which are from Taylor Wimpey against main contractors. The first one concerns a development in Gosport, which I understand achieved PC between 2006 and 2008. It was built by Morrison Construction, which was acquired by Galliford Try in 2006. It's now been renamed as Galliford Try Infrastructure. Taylor Wimpey is pursuing a BLO against 3 of Galliford Try Infrastructure's parent companies. In defence, Galliford Try is saying that BLOs should only be made in those limited grounds, which we saw from the explanatory notes. So essentially, they should only be made against developers and SPVs, not by developers against main contractors. If that's wrong, Galliford Try say that the claim is unparticularised and liable to be struck out because Taylor Wimpey hasn't explained why it would be just and equitable for a BLO to be made here. But in any event, and interestingly, they say that if there is going to be a BLO, it should be made against the previous owner of Morrison Construction, which was Anglian Water. And the reason for that is, as Jess said, a BLO can be made at any point during the relevant period, and the relevant period is any time between practical completion and the making of the BLO. So a potentially huge period of time. The next one is Taylor Wimpey again, and this is again against Ardmore Construction Limited. This concerns a development in North London called Aberdeen Lane, which I think was PC'd around 2013. Ardmore Construction was undertaking remedial works or fire safety remedial works at the development, but unfortunately Ardmore Construction entered administration in August this year. Taylor Wimpey is now bringing a BLO claim against Ardmore Construction's 3 parent companies. The defence is yet to be filed, as far as I'm aware, but presumably the parent companies will look to defend on a similar basis to Taylor Wimpey, but also the position that Wilmot Dixon has taken here in this case. So this is another claim against main contractor entities, is being brought by the London Borough of Hackney. It's concerning, again, it's fire safety, but also I think there's some structural defects involved here. The estimated cost of the remedial works are in the region of £30 million. Wilmot Dixon is at the same time bringing downstream claims against the architect and the structural engineer in separate proceedings. The interesting bits here is the arguments that Wilmot Dixon is raising in defence, or Wilmot Dixon's holdings, more accurately, is raising in defence of the BLO. So they say that Hackney has failed to pursue their other claims first. And they're also saying that they haven't benefited financially from the project. Now, both of those arguments didn't go very far in Triathlon Homes, so query whether there will be a distinction made here when we're looking at BLOs. The other interesting point from this one is that Wilmot Dixon's holdings did actually give the London Borough of Hackney a collateral warranty, but they didn't rely upon it prior to limitation expiring. So Wilmot Dixon are essentially saying, hold on a second, you knew about these defects when you had the ability to bring a claim under the collateral warranty, but you failed to do so. If to use a BLO would be unjust and inequitable, because you're essentially having a second bite at the cherry. And I can see the force in that argument. Interestingly, for our purposes, is this bit here on the slide. So Wilmot-Dixon understandably says this will have huge kind of negative implications for the construction industry. I couldn't agree more. In particular, exposes groups such as it to very large historic liabilities from which they derive no material benefit, but also for which insurers say Wilmot-Dixon Holding Limited is not insured. And the reasons they've given, at least in the pleading, is because the building liability order is a novel statutory remedy created by the BSA and operates retrospectively. Now, that's obviously in a pleading. It's not in a coverage dispute, but it kind of struck me that, yes, all of that stuff is correct, but that's not a reason of itself for the claim not to be insured. It's a reason why insurers might not want to insure the claim, but it's not a reason of itself. So it would be interesting to see how that would play out in a coverage dispute and how insurers are kind of interpreting those arguments by reference to the policy terms and conditions. The last one, again, I think this one is interesting because it's quite an unusual scenario. So what we have here is we have a architectural practice pursuing the material, the manufacturer of a product called K15, which is Kingspan Insulation Limited. The claim is essentially predicated on the basis that Kingspan Insulation made misleading statements in relation to the compliance suitability of the K15 product. I'm sure that most of the attendees will be aware of the evidence that was given by Kingspan in the Grenfell inquiry. So these claims, this won't be the only one. I'm sure that there are plenty of these coming out in the pipeline. BDP are then using that kind of underlying building safety risk claim to bring a BLO claim against Kingspan's parent companies. As I say, it won't be the only one. I'm sure that there will be many, but this struck me from the pleading, which said that one of the reasons why it wouldn't be just and equitable for a BLO to be made here is because it's unnecessary. So they say, if and to the extent that Kingspan Insulation, so the original entity, is held liable, it will be able to meet any judgment awarded against it. I mean, I think that's quite a neat argument, but probably only one that would work in isolation. And given the volume of claims which I suspect Kingspan is facing, BDP will probably want at least the comfort of having that BLO to rely upon if it needs it, and that's probably going to find some favour with the court, I suspect. So that's where we are. At the minute, there's no suggestion that BLOs can't be used beyond the example given in the explanatory notes, so beyond SPVs or developers. So we know that from Wilmot-Dixon. There's a risk, as we've seen from Click, that association of itself might be enough to persuade the court that it is just and equitable to make a BLO. BLOs can be awarded preemptively, as we saw in BDW and Ardmore, but query whether the facts of the case suggest that that's the right course of action, or whether actually you might, or it might be more efficient, cost-effective, etc., to include it as part of the main action. And the position around just and equitable is unclear, but I would say I think the indication we're getting from the Court of Appeal in Triathlon, and then certainly from the Supreme Court in URS and BDW, is that the BSA is very much intended to put things right, essentially. There is a purposive approach of this act, and the courts are going to interpret the just and equitable test in line with that purposive approach. So turning to coverage challenges, so the first and perhaps the obvious one, and it's one I suspect that some of you in the audience might be seeing on a fairly regular basis, is the ability to trigger the insuring clause in most PI policies. So as you'll be aware, most standard PI policies will respond to the act, error or omission of the insured in the kind of exercise of its professional activities and duties. The obvious thing here about BLOs is that it's not the BLO defendant's activity or duty or act, error or omission that is the kind of cause of the claim. It literally is a strict passing of liability from one entity to another. So there isn't usually going to be that that underlying act, error or omission. even if you can get over that hurdle, most PI policies will still have fire safety exclusions, and even if you can get over the insuring clause hurdle and you have a fairly wide fire safety exclusion, for example, in any way connected with, fire safety cladding, etc., that's probably still going to bite. If you were to look at your other policies, so the example here is a third-party liability policy. Those almost always require damage in order to trigger the insuring clause. Again, if we're concerned with cladding, that won't constitute damage. Cladding is defective, it's not damaged, it hasn't undergone any kind of adverse physical change, it's just defective, non-compliant. So again, you're going to be looking at difficulties in triggering the PL clause. And then this one, number 4, voluntary assumption. This is really concerned with developers. So as we were saying, we have the remediation contract, and essentially insurers might say, well, hold on a second, any liability that you've incurred as a result of that voluntary act, you entered into that contract for probably commercial reasons, pressures, etc. That shouldn't be down to your insurers to pick up, that you've voluntarily assumed that liability. But hopefully not all bad news, because we're now going to come on to some potential routes to cover.
Yeah, so as we've just heard from Rob, on the face of it, there are coverage challenges, but all is not lost, because subject to policy wording, there may be some helpful clauses which may extend to indemnifying an insured for BLOs. So firstly, you'll need to check the policy for a cross liabilities extension, or more commonly, carve-outs, write-backs to claims by associated or related companies' exclusions. While these typically exclude coverage for claims made by one insured party against another insured party, many carve out exceptions like the one on the slide. So on this particular wording, the policy excludes any claim made against an insured by an associated company, unless such claims are for an indemnity or contribution in respect of any claim made by an independent third party against the associated company. So how would this actually work in practice? Well, we'd need to check the definition of a claim, and we've given some example wording on the slide as follows. So a claim here shall mean demand for an assertion of a right to civil compensation or civil damages, or an intimation of an intention to seek such compensation or damages. So subject to the claim definition, this is where Section 1 of the Civil Liability Contribution Act may come into play. Because Section 1 establishes the right of a company who is liable to recover a contribution from another company who is also liable for the same damage. So if we go back to our example from the beginning, the freeholder has successfully applied for a BLO against Company B. Company B could seek a contribution from Company A in respect of the sum due under the BLO if the following 2 things can be established. So first, both companies would need to be liable in respect to the same damage. So in theory, yes, Company A does have a relevant liability for breaches of the DPA. And as Rob pointed out earlier from the Ardmore case, this doesn't have to have already been established. And Company B is liable for the breaches of the DPA by virtue of the BLO. Secondly, Company A and Company B must be jointly and severally liable for the same damage. And that would be satisfied as Section 130 of the BSA makes a BLO an order that any relevant liability of the original body, i.e. Company A, is also the liability of the associated company, i.e. Company B. So Company B would therefore need to make a demand or an assertion of a legal right against Company A based on it being entitled to a contribution under Section 1 of the Civil Liability Contribution Act. And that would satisfy the definition of claim in our example. But to make it more complicated in this particular example, the more likely claim here would be against the insurer or the joint insurers, because Company A is dissolved in this example. So it would be under the Third Party Rights Against Insurers Act. In practice, we suspect that there might be pushback from an insurer if Company B sought cover in this way, possibly including around whether the BLO with claim attached back to the original notification was the subject of prior knowledge and or restricted cover for fire safety claims in particular. But we consider this option could be a viable route for coverage for BLO subject to wording, and certainly worth considering further. Rob's now going to have a look at another potential option.
So this option concerns the ever popular topic of financial loss extensions. So those of you who are familiar with this already will probably be aware of the case of Tesco and Constable. This was a Court of Appeal decision from 2008. Essentially, Tesco had what was titled a contractual liability financial loss extension in its public liability policy. It then faced a claim under a collateral warranty from the operator, but not the owner of a railway line, for essentially loss of earnings or pure economic loss. Tesco thought, fantastic, I have a contractual liability extension in my public liability policy, so not a problem. Unfortunately, the Court of Appeal disagreed. So the Court of Appeal said that the contractual loss extension had to be viewed through the lens of the insuring clause, and the insuring clause very clearly, it said, only provided indemnity for losses arising under tort or negligent claims. So the extension didn't do certainly what it said on the tin. So helpfully, the court did say that there might be circumstances where this would be different, and that's at the bottom of the clause here. So the court said the wording may extend cover to third-party claims in contract, even for pure economic loss, although one would expect it to say so clearly and for such insurance to be described as contractual liability, financial or consequential loss cover. So the court was pointing to a fix, or at least we say it was, that might be made to the insuring clause, and it's on the next slide. It's just and this is quite a common way that it's approached following the Tesco case. So instead of legal liability arising in respect of, which was the wording in Tesco, to have wider wording, so in connection with, in any way related to, or consequent upon, followed by the usual TPL types of losses, so that it won't be restricted in the way that it was in Tesco, and hopefully your extensions will be viewed in that way. So turning to the financial loss extension itself here on the slide. So if we work through, so this policy is extended to indemnify the insured. So here the insured will be the associated entity or the BLO defendant against all sums which the insured shall become legally liable to pay. Fairly wide wording, and no reason why that wouldn't extend to statutory liabilities, i.e. BLOs, to pay in respect of any claim first made. So these extensions typically work on a claims made basis. So the claim being made here would be the BLO claim as opposed to the underlying claim against the original company. During the period for financial loss will be a pecuniary loss or expense incurred by a third party. So that third party is our BLO claimant, due to A, the defective or harmful condition of the insured products or completed works. Now that looks quite tricky because, and again, the nature of a BLO is it's not the BLO defendants act, error or omission, as we've seen, and it probably wouldn't be their product or completed works, which are the result of the loss. But we have here B, any contingency in connection with the business. Now, contingency looks like a very wide word to me. I did look it up in the dictionary, and it said contingency is a future event or circumstance which is possible but cannot be predicted with certainty. Now that seems very wide to me and probably could include any kind of unanticipated risk, so long as it's in connection with the insured's business. Connection, again, fairly wide, generous wording, but in connection with the insured's business, meaning any activity of the insured, including but not limited to. Now this, again, slightly tricky. Is the insured's business necessarily related to the activities of its subsidiaries or associated entities? I would say in group companies, and we were looking at the Wilmot-Dixon example and the Ardmore example, I would say yes. Parent companies would almost certainly be concerned with the activities of their subsidiaries because they will impact on their, operations, financial performance, things like that. I think the other point to make here is that if you are a kind of large construction practice or a group company, their general day-to-day business will almost certainly have been impacted by the Building Safety Act of itself. I mean, this act has fundamentally changed how all parties in the construction industry operate and the risks they're facing. So I would say, yes, these types of claims are a contingency in connection with the insured's business. So those are two examples. Just some wrap-ups before we go on to any easy questions. I think it's clearly an evolving and expanding area of law. We don't have, and it will take time, but we don't have that kind of body of case law to understand how the court is going to interpret a lot of the provisions in these sections of the Building Safety Act. That's obviously going to lead to probably a fairly prolonged period of uncertainty whilst people consider whether to bring BLOs, and people facing BLOs, decide whether or not to try and settle those claims or whether they defend them all the way to trial. There will be lots of case law coming out of these sections. Insurers will very understandably be looking to reduce their exposure where possible, but certainly we would be advocating to check and consider applicable policies, most likely your PI and your TPR policies, very carefully and view them in light of these provisions. Certainly, I've been guilty of it myself. Sometimes you're acting on a matter and you think, oh, I've looked at it in this way, I've looked at it in that way, but always worth going back and checking the policy wording when new facts come to light or claims evolve. And then lastly, consider coverage for related exposures. So we've got here warranty and indemnity and directors and officers. Certainly I'm not a specialist in either of those. We do have learned colleagues who of course are, but I think this one struck me, particularly the triathlon example. So W&I policies typically there to respond to liabilities which might not be known at the time of an acquisition. Certainly in the kind of freeholder and lender space, people acquiring kind of property assets and then finding themselves unbeknowingly becoming associated and at risk of BLOs. Query whether W&I policy might provide a route to some cover there. And D&O, this is really the kind of, and we haven't touched on it today, but it's the kind of prospective parts of the Building Safety Act. So there are some parts of the Act that give rise to a personal liability to make sure that higher risk buildings are safe. Query whether D&O might provide some cover for those types of liabilities. So questions, if we can. The first one is, how would you overcome the onerous notification provisions, also exclusion for rectification of contract works under general FL cover? That's a super interesting question. And of course I would say that. That is a really interesting question. I think this is the tension between whether it's a claim which is being notified to the original policy, whether it's a claim that's being notified as a freestanding claim under your current or live policy. And again, it's going to depend on the wording, but I think that the question is pointed in the sense that it's not going to be straightforward. Do you anticipate imminent changes under TPL wordings? Most probably, yes. I think that certainly the example we've given is probably a more generous financial loss extension, but there are others in the market, and yeah, I think it's inevitable that that type of cover, particularly for certain insureds and groups of insurers, will harden in light of this wave of BLO claims. Give it one more minute in case there's any other questions. Okay. Thank you, everyone. As I said, the slides and the recording are going to be shared. If there's any other questions, please feel free to get in touch with Jess or I directly, and we'd be happy to take any easy questions only, please. Thank you very much.
Thank you. Bye.